We're here at ABI's Views in the Bench program at Georgetown University Law Center, talking with Gary Holtzer from Weil Gotshal in New York. Gary just moderated a great opening panel on confirmation issues in complex Chapter 11 cases with several judges. So, Gary, one of the issues that we talked about in the panel is do creditors have a statutory basis to demand participation in rights offerings? That was one of the last issues that we talked about. There's a case from Texas and several other cases. So what's the answer? Is there a statutory basis?
So I think that the answer is it depends what aspect of the rights offering. When you're talking about the fee associated with backstopping the rights offering, the answer is no, as long as the fee is being given for the commitment to be there for in a rights offering and equity financing at the exit. If you're talking about a statutory right to participate in the actual rights offering itself, which is part of a distribution that creditors get, then in fact there is a statutory entitlement for you to be to receive that right in the bankruptcy. Now, there is the ability, and we talked about it on the panel, to differentiate, because you have to, between accredited and unaccredited investors, and you may have to separate them out in different classes, and that's been held to also be appropriate in a recent decision that we talked about on the panel. That the case was in front of Judge Bernstein.
Right. Well, great. Another issue that you talked about was substantive consolidation and the various rules of the road about when substantive consolidation is appropriate and proper. And one of the cases I found interesting was the diocesan bankruptcy case from Minneapolis, St. Paul, where the court ruled against the idea of the claimant's move for substantive consolidation. And so what was going on there, and what kind of factors are courts looking at when they decide subcon motions?
So I think, first of all, substantive consolidation is one of these issues that seems to arise every few years, maybe even 10 years, and then you see it thematically appear in a number of different cases. We talked about a couple of them today, and then it seems to go away for a while, and it'll be sleepy for a while, and then it'll come back. The case that you're referring to really raises the issue of how do you mechanically, substantively consolidate legal entities that are affiliated or non-debtor entities with a debtor. And I think where folks struggle is mechanically you are bringing into the bankruptcy all the assets, all the liabilities, and unless there's a notice process and a reason to figure out why to do it, you may be making the case worse. And I think where courts struggle, and our judges were actually reached a consensus on this, is if you're going to do it, then if it's an affiliate and it wants to be in the bankruptcy, it'll naturally file a voluntary. If it's not an affiliate or it doesn't want to be in the bankruptcy, which is presumably why it didn't file to begin with, then you're talking about an involuntary process, and the bankruptcy code has a mechanic for what I'll call following the rules. And so I think the consensus for this one is if you're going to have a non-debtor entity participate in the bankruptcy, you should simply follow the rules and go ahead and get it filed and move on from there. I think a simple motion for substantive consolidation is mechanically challenging, due process-wise, among other reasons, and that came out in the panel.
For sure. Great panel, Gary. Thanks so much for doing it.
Pleasure.
And we'll be back with the next panelists here from ABI's Views in the Bench.
Thank you.